retail or wholesale business, that can be very large companies or a lot of actually SMEs that play a very essential role, as we have also seen during this pandemic, in providing the people and the business with the goods and the services that they need, whether it is to feed them, or it is to clothe them, or improving and embellishing their homes, or to keep all the number of other businesses going when it comes to the many wholesale business as well. And providing European citizens and consumers the goods that they want, also with innovations and convenience. And consumers and citizens is what we will be talking about today with Commissioner Věra Jourová, whom we are very pleased to have you on board. Věra Jourová needs no introduction. She's been also in previous commission, and she's now Vice President for Values and Transparency, and been in charge for very important policy initiatives that have been released or will be released very soon. One is the on the rule of law, and also on the new consumer agenda. We do know that specifically the portfolio of Didier Reinders, but also under your supervision. Věra, it's very good to see you again. We had a number of meetings with you already over the past couple of years in your current incarnation, but also before. We appreciate the openness and the opportunities for dialogue. And we're very pleased to hear from you, and then having the opportunity to exchange. I will have my colleague Neil Macmillan, who is Director for Political Affairs and Trade at EuroCommerce, who is assembling and curating the questions for you on these two themes. So we're happy to hear from you. So we'll let you speak first, of course, on this rule of law and on the consumer agenda. Věra, the floor is yours.
Thank you very much for your warm welcome, and I want to confirm that I was very happy when I was doing the agenda of consumers policy, because it was very practical, very transparent. Everybody understood what are the main principles. The people appreciated that they as consumers are well protected, and also as for the businesses, I always tried to keep the right balance between the interests and rights of consumers and feasible solutions for the businesses. So it's a great pleasure for me to be back with you. I hope you are all healthy and in good physical and also mental shape in these heavy times. So again, dear members of EuroCommerce and dear Director General, thank you very much for inviting me for your webinar, and I am looking forward for the exchange of views on two issues which you already opened: the rule of law and the protection of consumers. First, I would like to recall the current health crisis and thank also for the key support of the retail and wholesale sector. Your work delivering the food and goods to the often isolated consumers is more important than ever, as member states seem to be moving into sharper measures or even lockdown measures against the background of the second wave we are currently experiencing. Your role will again be instrumental in keeping the societies going. And I am glad that we, the EU, together with member states and consumer organizations, have taken steps early on during COVID-19 to support the retail and wholesale sector. Cooperation with online platforms has proved an important cornerstone in the fight against scam products in the context of COVID-19. Following the Commission's call, online platforms have removed millions of unfair ads. Companies must take their responsibility and continue to only bring products to the European market that comply with European safety regulations. Member states also started reporting measures they took against unsafe products sold on their markets to protect against COVID-19 infections in April. We will continue to actively help both companies and member states to quickly remove unsafe products from the market. This is important for consumers and market participants who follow the rules. The COVID-19 outbreak is profoundly affecting people's lives, also with longer-term consequences. Consumer spending represents some 54% of EU GDP, and consumers' action must be an important part of the recovery. To maximize the potential of consumer spending in post-COVID recovery, we must reinforce Europeans' confidence and trust in consumer rights and their protection. At the same time, we should not impose an undue heavy burden on companies. Under the recovery plan, only a coherent and comprehensive EU consumer policy will be able to address new vulnerabilities and contribute to the collective and cohesive recovery under the green and digital transitions. New consumer agenda, a longer-term perspective, is another important matter I wanted to share with you where we are on that. The new consumer agenda will be adopted by the College by the end of this year. It is closely aligned with the needs of EU's economic recovery and transformation after COVID-19. The pandemic has not reduced but actually reinforced our need for a new long strategic framework for consumer protection, also on the long term. The priority areas of the new consumer agenda are consumer empowerment in both the green and digital transitions, addressing consumers' vulnerabilities, enforcement of EU consumer law, and international cooperation. In each area, we need to ensure, first, trust and transparency of responsibilities between national authorities, consumers, and businesses. Second, better information for consumers, including fighting false information. And third area, which will be highlighted in the new consumer agenda, is that consumers should feel safe and be reassured about their rights. The agenda will include a list of actions and initiatives for the next 7 years. Consumers can be important actors in the green transition, but in order to do so, they need information and protection. Smart cities and mobility, renovation waves, energy-efficient housing are all promising venues for consumers. In order to support the green transition, we will work on a legislative initiative on sustainable consumption. It will focus on products' lifetime and repairability, more robust tools to fight greenwashing and unfair product obsolescence practices, and minimum standards for sustainability, labels or logos, and information tools. The aim will be to ensure a level playing field and recognize those businesses that are willing to put more sustainable products and services on the market. On a similar vein, consumers will be key in making the digital transition a reality. In this context, we will work on the evaluation and revisions of both the Consumer Credit Directive and the General Product Safety Directive. Internet of Things solutions are promising for consumers, but they will be even happier to embrace this if the rules on liabilities are clear. The COVID-19 crisis has rendered ever more important the need to address effectively and urgently consumer vulnerabilities. This concerns any kind of major vulnerability, including those of financial nature, but also others, like susceptibility of some consumers to rogue trading practices, which have resulted in serious repercussions on consumer rights. Concerning consumer product safety, it is on the highest importance for the protection of consumers and the correct functioning of the single market to ensure that products sold to consumers in the EU market are safe, including non-food products. So the revision of the General Product Safety Directive will take into consideration, among others, new technological changes, such as the growth of online sales and ensuring safety of connected products and products powered by artificial intelligence. This will be done in synergy with other initiatives, like the revision of the e-commerce directive. It should also ensure a clearer legal framework and a better level playing field for businesses on and offline by, for example, clarifying the obligation and responsibilities of the different actors in the production and distribution chain, or enhancing coherence in the legal framework of harmonized and non-harmonized products. Finally, an issue that has received much attention in recent years is the need for better compliance and enforcement of consumer rights. This year's political agreement on the new Representative Actions Directive is very encouraging. The Commission will work closely and intensively with the Member States for its transposition and application once adopted. I repeat, the aim of the directive is not to bring additional burden to the economic actors, but to give consumers a better tool for protecting their existing rights. The checks and safeguards agreed by the legislators have strengthened the anti-abuse measures, and I am very glad for this. In all these areas, a key cross-cutting element will be the cooperation between Member States and the Commission, but also with stakeholders, including businesses. So this is the right moment to thank you for your contribution to the Consumer Agenda consultation, and I look forward to continue our dialogue and cooperation to tackle challenges, especially for digital and green transformations. Allow me now to turn to another very important matter, the economic importance of the rule of law. Respect for the rule of law is not only one of the fundamental principles governing the European project as such. Respect for the rule of law is also necessary for an effective single market. There cannot be an effective single market without mutual trust, and there cannot be mutual trust without respect for the rule of law. We have highlighted the beneficial impact of well-functioning national justice systems, legal certainty, and respect for the rule of law for the economy in the context of the European semester cycle of economic, fiscal, and social policy coordination. In recent years, we have seen a deterioration of the rule of law in several member states. Such deterioration led to the opening of the Article 7 procedure by the Commission against Poland and by the European Parliament against Hungary. And these are unprecedented steps in the history of our Union. In recent years, the Commission has also deployed other instruments to protect the rule of law in the Union. Under the European semester, several country-specific recommendations on justice reforms in member states were adopted by the Council, stressing the link with the investment climate. Also, the Commission has initiated a number of infringement procedures on the rule of law and respect for EU values. On some of these procedures, the European Court of Justice has already given its judgments, and we will follow up closely to ensure that they are complied with. Some other infringement procedures are ongoing, and we will act diligently on them. While some results were already achieved through these Commission's actions, it was more and more evident that we need additional rules. And I am glad that this year we have taken steps to strengthen our toolbox with the new rule of law tools. Firstly, we have a new tool in the Commission's rule of law toolbox. Here I have in mind the annual rule of law report. The first report was adopted on the 30th of September. This report is at the center of the new European rule of law mechanism, whose objective is to deepen dialogue and joint awareness of the rule of law throughout the EU. It is a yearly process aimed at preventing problems from emerging or even deepening. What we want to achieve through this report is a true dialogue at EU and at national level. The report covers both positive and negative developments in the Union, including a country-specific assessment of all 27 member states. In our annual report, concretely, we looked at 4 key areas: the independence, quality, and efficiency of justice systems. The second is the anti-corruption framework. The third, media pluralism and media freedom. And fourth criteria or topics we were looking at were institutional checks and balances. Let me stress again, what we want to achieve with the report is a launch of a debate and promote a rule of law culture across the EU. And also, I have to stress here, I count on your support in our joint mission to uphold and strengthen the rule of law in the EU. Secondly, because I mentioned that we are going to enrich our toolbox by two instruments. So the second tool is still in the making. And I hope we are close to having an agreement at EU level on another rule of law tool, which is protecting our budget and the respect for the rule of law, which I believe go hand in hand. We must do everything we can to protect European money by stepping up the fight against fraud. This means having the right controls in place, including a database that puts us in the position to know who the final beneficiaries of EU funding are. The European Council of 17th to 21st July this year has underlined both the importance of protecting the EU's financial interests and the respect of the rule of law. Its July conclusions confirm these objectives and call for a regime of conditionality to do this. Against this background, negotiations are currently ongoing between the co-legislators on the proposal made by the Commission in this regard already in 2018. So, ladies and gentlemen, I call on your support to uphold the rule of law wherever you undertake your activities, because your voice needs to be heard. Thank you very much.
Thank you very much, Věra, for those laying out the ground for I believe will be a good discussion. I think we have 40 minutes left. I think for having a good exchange, and we know that I think this exchange can be very, very lively and vivid with you, and also humorous from time to time as well, even when they are dealing with some serious subjects. So I suggest we probably cluster the questions, maybe starting with questions indeed on the rule of law. And I ask Neil that I mean, so all of you have the opportunity to provide questions, live. But we also have had a number of people who have forwarded some questions to us in advance already when they registered. So perhaps if you agree, I think, Věra, if we can take maybe 2 or 3 questions at a time, and then you answer those, is that okay with you? So Neil, what have we got?
Okay, well, again, may I add my welcome to the Vice President as well, and our gratitude for you taking time to talk to us. We've had some questions coming in live, but we also had some submitted over the last couple of days. I think I'll start just with 2 because this is a slightly complicated question. The first one is that the Commission Rule of Law report obviously showed a number of major shortcomings in a number of countries. our members are major investors in some of those countries, and particularly across Eastern and Central Europe as a whole. But they're facing real issues in terms of legal certainty, and that they see their ability to continue to trade badly affected by sometimes rather arbitrary action. The problem they have, I think, is that they only have very limited redress to national authorities and to national courts, where the judicial system is in many countries under severe political pressure. The question is, how can the Commission best address these breaches of what we consider to be basic principles of the rule of law? And the second question, which has just come in, is how can national parliaments play a role in creating a rule of law culture across Europe? So I'll leave those two for you to answer first, if that's okay.
You said there will be several questions, so is that?
Well, those are two, but if you want a third one, I'm very happy to give you a third one as well.
Okay. Yes, the third one, please.
Okay. Okay, the third one is really relating to what you just described in terms of the action that the Commission has put forward in terms of a link between money and the rule of law. That's obviously very important in respect of the recovery program, where a lot of money is going to be available to member states. And what the question relates to is the apparent watering down of the linkage that the Commission was proposing to the Council. And the real question is, how can we ensure that these countries take seriously the need to protect the money which ultimately European taxpayers are going to have to find, and also that this linkage is not completely ignored in those countries. So I think there are three questions there, so I shall ask.
Yeah, and I think maybe if I can echo the last point as well, we have very strongly also supported the issue of conditionality of the MFF and the EU budget to the rule of law, and of course for us the rule of law is also in respect to the single market and principles of proportionalities and fair treatment, which, as you know, retailers and wholesalers in a number of countries have been subject to to blatant discrimination, to the point where indeed I think investments are being questioned. And I think that's also related to the first questions that Neil raised, is how can we ensure that indeed there is a certain amount of certainty that those investments will be protected.
Yes, thank you very much. This is exactly the voice of business which we need to hear from time to time, because the Commission cannot be alone in the fight for restoring the full trust for well-functioning rule of law principle in all the member states, which was the situation still, I would say, 10 years ago, maybe, when we lived in a naive idea that the rule of law principle, the checks and balances, the independent and impartial professional judiciary will work automatically everywhere. We were naive, and we also were naive when we designed the Lisbon Treaty, where we have the instruments to manage such situations. The most hard measure is the Article 7, which is by some called atomic bomb. When we triggered Article 7 in case of Poland, it was mentioned many times that this is the atomic bomb. It shows that it's not, because it doesn't work. We got stuck in the council in the talks on Poland and later on Hungary, which was triggered by the parliament. And so I don't want to say that there is a useless debate. The debate is very important, which is ongoing in the council, because the member states also should work on better definition and better common understanding what we mean by the rule of law. But Article 7 is not the omnipotent, the magical solution. I didn't believe we will ever trigger Article 7, but here we are, and that's the reality. Then the infringement procedures. We have used this several times. Now I am answering on your question how the Commission can solve the issue, just to be clear. And we are using infringement possibility or violence of the EU law. Not all the rule of law issues can be solved by infringement procedures. It has to be said. That's why we tried to come with a better solution for stronger prevention. That's why we came with the rule of law report, with the annual regime of the rule of law report. And that's why we are also mentioning the rule of law issues in the European semester, which is directly linked with the conditions for the businesses and for economy. For very good reason, because when we see the backsliding or deviating from the rule of law principle in some of the member states, this is a damage for the whole European judicial system, because in European judicial system or justice system, we rely on the functioning judiciary in all the member states. We have a lot of instruments based on the mutual recognition, for instance, the European arrest warrant. And so this is when we have a deficiency in one or two member states, the whole system is damaged. That's why we are pushing through all means the member states to respect the rule of law principle. And what is there for the business? Well, you defined it very well in the question, that the businesses need legal certainty. They are afraid of effect of arbitrary actions from the side of different state authorities, which are not fully under the control or under the supervision of independent judiciary. So we receive a lot of complaints from the business side, and that's why also for the sake of well-functioning single market, the Commission does everything and uses all the tools and legal competencies to push the member states where we see the deficiencies to come back and to restore the legal certainty for the businesses. Where we are on that, you can judge yourself, because I am sure you follow this issue. What can the national parliaments do? I will come back to the Commission before the national parliaments. I forgot one thing. The rule of law report as a preventive measure. As I said in my opening remarks, should open the space for honest and high quality discussion with the member states where we see the worrying trends. And when I am in the European Parliament, and when I speak about what we are doing in rule of law agenda, and when I speak about being asked about the situation in Poland and Hungary, I will always repeat that we have not given up the discussion and dialogue with the member states where we see the problems. Because when the dialogue stops, I cannot imagine we can ever restore good old normal we cannot improve the situation. There must be two for this dance. The national parliaments can do the main thing, not to adopt the reforms of judiciary, which will result in politicization of judiciary, which will end up the independence and impartiality of the decision-making of judges, which will cause pressure, which will bring pressure on the judges, and which will have, and the pressure which will have a chilling effect on the judges. The reforms are very much welcomed by the Commission. The reforms which improve the efficiency of judiciary system, the access to justice from the citizens and from the companies, which will bring speedy more speedy decisions, because to wait 5 years for a decision of the court, it's not a healthy situation. So we welcome the reforms, but the reforms have to respect the limits and must not result in what I said before, in politicization of judiciary and ending up their independence, the independence of the system. And also here, the national parliaments can look into our annual reports on rule of law, where we tried to honestly and on the basis of transparent methodology describe the situation in each member state using transparent channels of information. And we expect, and we would like to now start with Didier Reinders, the dialogue with the national parliaments on how they see the situation, so that we also do everything on our side to have the dialogue with the member states, with the proper institutions, and who else than the national parliament, where is the place where the either good or bad reforms can be adopted. I know I speak very long, but the last thing was the money, connection between the money and the rule of law. You hear no humor from me today. I am usually trying to spread good mood, but we are in a serious situation and we are speaking about serious things in serious circumstances. So the jokes are not appropriate ones, but this is not a joke when I say that no, I will not say it. Seriously, there was and there is something substantial missing to convince the taxpayers in the EU that their money will end in good projects, helping all the people, helping those who need help, because especially the cohesion funding is based on the solidarity and on helping those who are in some more difficult economic situation. We need to convince the taxpayers that the money will not end up in the pockets of the people who corrupt, who use unfair practices, who abuse the power for giving the money to the friends or to the family. We need to enrich our toolbox by something which will help us to convince the taxpayers that the money goes in the right things. And the conditionality we proposed in 2018, which indeed was modified over time. At the beginning, we proposed something which will protect the rule of law. Now it's more the proposal which seeks to protect the EU funding. Yeah, we saw the process. But nevertheless, this is very important that we continue the negotiations. I am not in the negotiating team on behalf of the Commission, so I have indirect information. But I know that the negotiations are intensive. Politics is the art of possible. So I think it is now applied in the negotiations. The Council is coming with the proposals which have to be considered by the Commission. The Commission is the honest broker now in the negotiations between the Parliament and the Council. But I can tell you what the Commission wants to achieve. The new tool, which will be fair, which will bring sufficient legal certainty, especially for the member states, which will be applicable and which will be efficient. And these are the principles our negotiators, I'm sure, are promoting in the negotiations. It's not easy. The time is running. We need to have the budget adopted. so that we can use the recovery money as soon as possible. So the situation is very tense, and I still do believe that the negotiations might result in a good outcome. And all that started in 2018 when I personally was frustrated that Poland and Hungary didn't join the European Public Prosecutor's Office, if you remember that time.
Yeah.
And so
talking a bit about
it has some history. Now I am silent. No.
Talking a bit about politics, and I think you've been quite in the news recently on exactly this sort of issue. And I think we have a question from one of our viewers on this, Neil, right?
Yeah, indeed. And maybe I can group that, since I'm not sure how you want to answer it, but I'll group that with two other questions, which can perhaps also then transition us to questions about the consumer agenda. So one of our viewers at the moment has said both the Polish and Hungarian authorities said they will do what it takes to avoid any conditionality between EU funding and their respect for the EU values and the rule of law. As we discussed before we came on air, some prime ministers have indeed asked you to resign because this is intolerable, what you're demanding. But you said that you were in dialogue with a number of the member states. Is that including Hungary? And is there any way of perhaps actually getting them to understand that conditionality is not an attack against them, but actually a part of the way that the EU needs to operate? I have a very specific. Yeah, sorry, go on.
Okay, still on the rule of law, or?
Yeah, I've got two more, which one of them transitions to consumer agenda. We have a very specific question, and if you can't answer this, please don't feel obliged to try and do so. This was about Bulgaria, and apparently there is a cooperation and verification mechanism for Bulgaria, which the question is asking, will there be new monitoring reports which can reinforce what has been said in the rule of law report? And transitional question is about privacy rights and the idea of the empowered digital consumer. How does this fit in with the rule of law process and the consumer agenda?
So
can you specify again what is the last question about, please? Digital rights?
Yeah, it's about the privacy rights and how those could fit in both the consumer agenda and also the rule of law agenda.
How much time do we have? This is
I think if you can answer this because I think we have quite a few questions.
We have quite a lot of other questions. Yeah.
This last one is pretty broad one, but the first question on Poland.
And we have quite some more questions on new consumer agenda. So if you can be brief on those ones, thank you.
Don't worry. On Poland and Hungary and their reactions on the conditionality, I want to stress one thing. The conditionality is not an attack against anyone. This is not attack. This is the instrument which should, first of all, work as a preventive tool, but indeed it should be applied in case the situation requires such measure. And the list of criteria and triggering situations is now being being more concretized, it goes into more details. As far as I know, the negotiations are very much focusing on the scope, I want to reject this rhetoric that this is going to be used as an attack. And the European Council conclusions from July are clear. The respect for the rule of law and the connection with the budget was confirmed by the summit. And Ursula von der Leyen promised to come with improved proposal. And the proposal is now being negotiated. So I just wanted to say that this, and I said it before, so I don't want to prolong that. Bulgaria, indeed, we are now running 2 parallel processes regarding Bulgaria. One is the cooperation and verification mechanism, which was started upon accession of Bulgaria to the EU, and it is ongoing, I think more than 10 years now, and there is some unfinished work still to be done according to the last report and last assessment. And in the rule of law report, there is a clear reference that after this so-called CVM mechanism finishes, Bulgaria will get only into this rule of law mechanism yearly assessment. So we are in transition now, and Bulgarian colleagues know it. Commission is very open and very collaborative. We are supporting the process of remaining parts of reforms which are foreseen for Bulgaria, and I cannot predict now when the CVM will be ended up. Well, it depends on what will happen in Bulgaria. This is about fulfilling the things which Bulgaria committed to do, and about the sustainable solutions, because we do not want to see the reforms on the paper enshrined in the law. We want the reform to work in practice. So, but indeed, transition time, and Bulgaria is aware of this process. Bulgarian government, to be precise. Digital rights of consumers. Well, and privacy. As you know, previous commission did a very important step forward, and it was GDPR, when we said no, nor the citizens, neither the consumers, who are the same people, should be treated as individuals who have guaranteed their fundamental rights. One of them is the right of privacy. And GDPR was a revolutionary step forward in that, because before GDPR, there was a tendency especially in big tech space, in big platforms, to handle the people as a crowd, which was easy to manipulate, easy to chase into the algorithmic bubbles, easy to provide the private data for any undefined use. So it was a big step forward. Then we came with several other proposals, which, for instance, and you remember that, came with, for the first time, with the rules for the situations when you pay the digital product with your private data. You remember me saying many times, when somebody is offering something for free, make sure he wants to sell it yourself, because this is exactly the situation when you pay with your private data and you don't know it, that you are paying with your private data, and that what your private data will be used for, how it will be monetized. So we want to continue this path. We will now adopt several important pieces of legislation regarding the rights of people in digital space. It's heavily needed because we want the technologies to serve the people and not vice versa. But I promised to be short, so I will stop here. And if you have some additional questions on that, I'm ready.
Okay, maybe we can. Sorry, go ahead.
No, I think go ahead. I think now we have a set of questions on the new consumer agenda. I think but go ahead, Neil.
Okay, that's great. We've had a number of questions come in, but also some questions posed to us a little bit earlier. And I think I will start with just one question on that, because it is actually an important point for a number of our viewers, so to speak, at the moment. This is really to do with products that are coming in through direct imports, particularly from China, but from some other third countries as well, usually on platforms, and sometimes not always very clearly until you get it, something which is actually being dispatched from China. So the real question is, how can the consumer agenda address in a rather better way than at the moment the rules can, the question of non-compliant and in some cases actually directly dangerous products which are bought online through these platforms, and not only the safety aspect, but actually also the question of consumer rights, which often you have none essentially as a consumer buying these things. So how can we get a level playing field between EU traders who have to respect these rights, whether it's on safety or on product liability more generally, and how can therefore the Commission balance the obligations that we face with these external players and the externalities that these create to create that level playing field? Maybe you'd like to answer that one first.
Yes, I will be shorter. Indeed, this is a very complex issue, and I remember well how intensive pressure we were continuously imposing, especially on China, or mainly and maybe in sometimes only on China, together with the partners from the United States to decrease the percentage of the dangerous products which go to our markets, to do a much better control on the territory of China, to focus on online sales systems, and so on. Year by year, we saw a decreasing number of Chinese dangerous products caught in RAPEX system, but it was I think, if I remember well, 2016, it was 65%. At the end of the previous commission, we got somewhere close 50%. It's still very high, and it is very clear that the safety of products and the international matters have to play prominent place in or role new consumer agenda. It will propose further intensification of the international product safety oversight and cooperation with China and also other international partners. According to my information, because now we are preparing the agenda in the Commission and the process is ongoing, but we would like to establish a new action plan with a specific focus on products sold online to help exactly what I spoke about, reducing the number of unsafe products sold directly to EU consumers. But I can tell you also from my experience, the negotiations with China are not easy, very difficult circumstances. You probably noticed that we came with the new strategy towards China, that there are things where we are cooperators, somewhere we are competitors, and somewhere in some other things we are rivals. And I would really like to increase the push on China to be the partner who is cooperating and who understands the tough requests from the EU side, because for us the product safety is the highest priority when I look at consumers' agenda. And Didier Reinders and Executive Vice President Dombrovskis will increase their efforts to establish a more level playing field with China and Chinese companies and the benefit of both European and also Chinese consumers.
Thank you. Thank you very much. And Neil, I think the next set, perhaps last set, let's see how far we get, but I think we're on the sort of balance between consumer agenda, sustainability, and responsibilities and needs for businesses, please.
Okay, if I can group a couple of those together, and I think we're probably going to run out of time after that, so this may well be the last question. I think the first point is, as Christian said, there is obviously a need and this is a priority which the Commission has clearly stated already, for consumer law to keep pace with the green and the digital transition. But how will you approach this in terms of also a balance between those very important objectives and businesses which at the moment are really quite struggling, particularly in the non-food area, with the COVID crisis and the likelihood of, again, some lockdowns in some countries? I think there's also a question, therefore, also that if the obligations get too much, that it will also affect consumers in a potentially negative way. I think the other question I would like to ask you is about how we can make sure that there's a level playing field also within Europe. One of the things that many people have said is a problem, and this is something which we as an organization have also stated a number of times, that there are massive variations in terms of consumer law between member states, particularly in respect of legal guarantees. You have some who stick, and indeed the majority who stick to a 2-year guarantee, but other people gold plate that. And it does actually mean that people hold back from selling across borders to some of those other countries. We were wondering whether this is something the consumer agenda might be able to play a role in.
And if I can maybe add, one, I think also in issues of responsibilities across the supply chain, because retailers very often end up, with thousands of products, etc. And when it comes to durability or information on sustainability, sometimes I think responsibility is pushed down the chain to, it's for the retailers to, one, address all the questions, and two, also be responsible for all defect products. Whilst I think there is also responsibility for players also upstream in the supply chain.
Yes. Thank you very much. Well, the Green Deal and Circular Economy Action Plan. These are big plans which will affect everyone who lives in Europe, everyone who does business in Europe, everyone who operates on European market, because the requirements are and will be very high. And I would say the requirements which correspond with the level of risk and threat we have in the sense of climate change. So we had many discussions at the beginning of this commission how to do that, to find the right balance, and how to distribute the obligations and the burden on different parts of our society. We always agreed on the principle that whatever legislation we adopt, we will always have the proper impact assessment, which will focus on the impact on different countries, different regions, different sectors, different layers of the society. I spoke before about vulnerable consumers. Well, the consumers should not be those who pay most, because of course they play important role in all that. We will ask them also for joining us in changing their consumers' habits and behavior and paying more attention to the green aspects. But we have to distribute the burdens in the right way. And this is not about political declaration. This is about the proper work with the data. That's why I am mentioning the impact assessments. Whenever we adopt the legislation which is under the roof of the Green Deal, we expect that in the legislative process there will be a very sometimes difficult and very rich discussion in the European Parliament and in the in the European Council and the different formations of the Council, because it touches upon, among other things, for instance, the food field and the energy sector. So it is cross-cutting topic, and it will be tackled on many different political tables, and I hope also in a very broad public discussion. Because if we want to be successful on Green Deal, we need to invite all the people to take part in it, and we need to convince the consumers that it will pay off to pay more attention to the green aspects. There will be a lot of, as I said, tough negotiations. There will be, I'm sure, different approach from the member states, how far to go in some of the plans, but that's life. It's the life of European decision making. That it's a very broad process. And as the Commissioner responsible for transparency, I also want to stress that we are now pushing on having more transparent legislative process, so that everybody can look who was lobbied by whom and who had talks with whom, because I think that especially when we are adopted the legislation which will affect everybody and which will not be business as usual, which is clearly not this case, the people should know who is influencing and to what extent the decision making of the European legislators. So you see, I did the circle to my agenda again, to the agenda of transparency. And if I may go on the massive variations of the conditions, well, indeed, I'm afraid that you will not find, according to what I received from Didier Reinders and his team, the information, these matters bordering with the single market rules and obligations will not be directly addressed by the consumer agenda, but we will, of course, review the relevant legislation in due time over the next period. But you will not find it among the main strategic aims of the agenda. I can only add from my experience, I'm sure you remember, very difficult work around the digital contracts when we tried to harmonize the contractual conditions, exactly for the sake of easing the possibilities of the businesses to use the whole European single market, and how difficult it was to harmonize the contractual rules with all the member states, because we entered into the holy space of the civil law.
But does that mean that you're not prepared to really do something stronger to stop the gold plating of this legislation? Because at the end of the day, if we really want a single market to work effectively for business, we need to have, I mean, as I said, for passenger rights, for example, on airlines, I think there's very much similar rules everywhere.
Yes,
I know the consumer organization don't want to tackle that and approach that, but I think that's something that where businesses would really like to see, you know, more harmonized rules and not gold plating, so sort of maximum harmonization as opposed to minimum harmonization.
By saying that there is a very strong resistance from the side of the member states against the invasion of the Commission into these civil law matters, I am not saying that the Commission is giving up. The question was whether it will have a prominent space or place in the new consumer agenda. There are other priorities, but at the same time, we will review, as I said before, the relevant legislation in this mandate, and we will look into whether we can achieve some more harmonization, because the request from the side of business is very logical, very clear, very justified. So I'm aware of that.
Thank you very much, and it is 12 o'clock noon, so perfect timing to wrap up and conclude this webinar. Vice President Jourová, very much heartfelt thanks for engaging with us on a continuous basis, and specifically through this webinar, which people can actually also watch afterwards as well. So, and I think just to also to make sure I think you knew it, but I think this was the invitations went not only to our members, but also to many of our friends and stakeholders within the European Union. So we want to engage in these policy talks also with many other people across, and friends and foes of retail and wholesale. And we look forward to continue working with you, supporting in your courageous work on the rule of law. You have our support on that, whatever, and we can do to help you. So thank you for your participation. Thank you to all the participants on this second webinar. The next one will be on November 9 with Executive Vice President Timmermans on the Green Deal. And in the meantime, what I would suggest, Vera, is if for all the questions that we may not have been able to take on, that we engage with your with the services and with your cabinet and pass those on, because some of those questions, even if we don't get the answers now, are at least probably interesting reference point for you to see what sort of concerns are still living within the community.
Yes, well, I can tell you the questions are very often more important than the answers.
Very good. Thank you all very much, and for your participation, and look forward to seeing you, and thank you all to your participation. Bye-bye.
Thank you. Have a good day. Bye.
Bye-bye.